The Supreme Court on Thursday reserved judgment in the suit filed by President Muhammadu Buhari and Attorney General of the Federation, Abubakar Malami, to void provisions of Section 84, subsection 12 of the Electoral Act 2022. On May 19, the Apex Court admitted an application filed by Rivers State to be joined in the suit. Justice Musa Dattijo, who led the 7-member panel of justices of the Apex Court, allowed the joinder application that Rivers brought through the Speaker of its House of Assembly and its Attorney General, and adjourned the hearing on the suit until May 26. The applicants told the court that they were opposed to the suit, which originally had the National Assembly as the sole respondent. President Buhari and Malami filed a suit at the Supreme Court seeking an interpretation of Section 84, subsection 12 of the Electoral Amendment Act 2022. They are seeking an order of the Apex Court to strike out the section of the Electoral Act, saying it is inconsistent with the nation's constitution.
Coming as invoking the original jurisdiction of the Supreme Court, and that has a stipulation that is provided for. It has a niche upon the persons who can bring such actions. So we realize it is not, we are not part of those persons who the Constitution has provided and the Supreme Court Original Jurisdiction Act has provided for. So the essence of us withdrawing is for, we've seen that parties like Rivers State have joined and other parties have joined. They are also included in the Original Jurisdiction Act. So with that, our withdrawal is just for an easement in the dispensation of the case.
We as MBA, we have done our duty to Nigerians, which is our obligation to ensure that we protect the rule of law in Nigeria. What we have done today is that in the discussion of this matter that affects Nigerians, at least the Nigerian view should be heard.
Is that the appeal has been argued, and the court has adjourned to such a time that they will notify us. At this point, we don't know when the judgment will be given. But I think that the matters are very straightforward, as you all heard while you were inside the courtroom. So I do not really come out to go and start arguing my case before the press.
You don't jump. When the decision comes, then you decide what to do with it. And in any event, don't forget, the decision or the declaration that the president is seeking is not for his own personal interest. It's not contesting any election. So, and also, it is also for the future. It's both for the present and for the future. So, but when we get to that bridge, we will cross it.
Any party can bring any issues, any objection. It is the duty of the court to look at it and to quickly. And in that light, let me use this opportunity to salute the courage of the Supreme Court for taking and placing premium in this matter. This is the matter that started about a week or 2 weeks ago, and you can see the dedication to duty to ensure that this matter is quickly dispensed with. I'm very sure in the next few days, few weeks, though I'm not predicting them, we will certainly get to the end of this matter.